Welcome back, dear students. Today we will learn how to draft an application for temporary injunction under Order 39 of CPC. My dear students, you know that under Specific Relief Act, permanent as well as temporary injunctions can be granted. And you must know that permanent injunctions are granted at the end of the suit. When the suit is decreed, their lifetime is also perpetual. They are applicable forever. Whereas temporary injunctions are granted during the pendency of the suit and their life is limited as fixed by the court or up to final disposal of the case. They are vacated whenever the suit is decided. So this is the position and distinction between a permanent injunction and temporary injunction. In order to obtain a temporary injunction, a plaintiff has to show following three ingredients. Why I am emphasizing on these points? Because unless you know the ingredients required for a temporary injunction, you will not be able to draft an application for the same. So here are the three ingredients which are required in order to obtain a temporary injunction. A, that the plaintiff has a prima facie case. You will have to explain it to the court, show it to the court that plaintiff has a prima facie case. Then B, second part, that balance of convenience is in his favor. This means that if injunction is not granted, plaintiff will suffer more damages, more harm as compared to defendant. If injunction is granted, then defendant will suffer no harm, whereas plaintiff will suffer a great harm. So this is balance of convenience that is also in favor of the plaintiff. And third, C, that he will suffer irreparable loss and injury if temporary injunction is not granted. Dear students, when you will work as an advocate, obtaining temporary injunction is very important in your practice. If you succeed in getting temporary injunction for your client, you rather you have won half of the case once you get the temporary injunction. Now with this background in mind, now we will start drafting the application for temporary injunction. This application can be filed in any court wherever the matter is pending. It may be subordinate courts, it may be the court of district judge in first appeal, it may be high court in second appeal, or this temporary injunction application can be moved even in Supreme Court. So I'm repeating the old illustration, and the name of the court is in the High Court of Delhi at New Delhi. Ordinary original civil jurisdiction, suit number dash dash of 1990, in the matter of, as such, our plaintiff is X, son of A, with complete name and address as plaintiff. X, son of A, resident of Block C, flat number 409, Palam Vihar, New Delhi, is the plaintiff, versus Y, son of B, resident of 52 Palam Vihar, New Delhi, is our defendant number 1, and Z, son of C, resident of 53 Palam Vihar, New Delhi, is our defendant number 2. Now center heading is application for temporary injunction under Order 39, Rule 1 CPC. The opening salutation sentence will be: the plaintiff most respectfully submits as under. Para 1, that the plaintiff has filed the present suit for specific performance of the contract of sale of immovable property, along with prayer for declaration of sale deed of the same disputed property done by defendant number 1 in favor of defendant number 2 as null and void. Dear students, these facts and these illustrations I had adopted while discussing the drafting of suit for specific performance, declaration, and permanent injunction. So same set of facts I have adopted here. for drafting of this application for temporary injunction. And if you remember, in this illustration, the defendant number 1 was bound to execute sale deed in favor of plaintiff, but during pendency of the suit, he transferred the property to defendant number 2. Now the plaintiff is worried that he may not further transfer the property to anybody else. So that is the main point for getting temporary injunction, requesting the court not to grant temporary injunction to such a person so that he may not transfer property to anybody else. So para 2, that the plaintiff has also prayed for permanent injunction against defendant number 2 so that he may not transfer the disputed property to anybody else during pendency of the suit. Para 3, that plaintiff has come to know through advertisement in Hindustan Times newspaper dated 30th May 1990 that defendant number 2 is trying to sell the disputed property to third parties inasmuch as he has given an advertisement in the said newspaper for sale of disputed land. And para 4, defendant number 2 is negotiating to sell the land in suit to third party at further higher rates with a view to defeat the claim of the plaintiff. Para 5, defendant number 2 had full knowledge of the agreement between plaintiff and defendant number 1 and has knowingly purchased the land in question from defendant number 1. Para 6, that plaintiff is ready and willing to perform his part of the contract. So this is also compulsory to write that plaintiff is ready and willing to perform his part of the contract. Although there is now amendment in the law, Specific Relief Act has been amended and there is no need of writing this paragraph. But still, as an advocate, I advise you to always write down this paragraph on behalf of the plaintiff, that plaintiff is ready and willing to perform his part of the contract. Now, para 7, now you will write down those 3 essential ingredients of temporary injunction. So para 7 takes up the first ingredient, that the plaintiff has a strong prima facie case in his favor because he has a live and registered agreement dated 1st July 1989 to purchase the disputed land, and he has paid advance money too. Yes, he has already paid advance money to defendant number 1. Para 8, talking about balance of convenience, that the balance of convenience is also in favor of plaintiff because plaintiff will be placed in a very inconvenient position if defendant number 2 succeeds in selling the disputed property during the pendency of this suit. Now coming to the third ingredient, that plaintiff will suffer irreparable loss and injury if defendant number 2 remains successful in selling the disputed property to third parties during the pendency of this suit. The plaintiff will have to join the prospective purchasers as party to this suit, and there will be no end to the litigation. On the other hand, defendant number 2 will suffer no harm if he is restrained from selling the disputed property. Para 10, it is therefore necessary in the interest of justice to restrain defendant number 2 from transferring, selling, assigning, gifting, mortgaging, or otherwise alienating the land in suit or any part thereof, or entering into any agreement for any of the said purposes, and or parting with possession of any part of the said land, or change or affect in any manner, directly or indirectly, the land in suit in any manner, themselves or through their agents, servants, representatives, or otherwise during the pendency of present suit. Now the final prayer is that it is most respectfully prayed that defendant number 2 may kindly be restrained from selling or parting with possession or making any agreement to sell regarding the disputed land during the pendency of the present suit. So this is the final prayer. And at the end of this application, plaintiff is supposed to sign it. And since the application is drafted and is to be moved through counsel, so you will write down through counsel ABC advocate. And of course, this counsel will also put the signatures on this application. You will mention the place of drafting New Delhi and date of filing is 1st June 1990. So signature of counsel are also required. On this application. So dear students, this is how an application for grant of temporary injunction is to be drafted by you. The purpose I told you that in the beginning there is a distinction between permanent injunction and temporary injunction. Temporary injunction is granted during pendency of the suit, whereas permanent injunction is granted when the suit is finally decided by the court. And life of the temporary injunction is as fixed by the court or maximum during pendency of the suit. When the suit is finally decided, either it is decreed or it is dismissed, the life of temporary injunction comes to an end. So the life of temporary injunction is from the date of granting till the period which is fixed by the court or maximum up to the date of judgment. When the judgment is pronounced, suppose your suit is dismissed, then this temporary injunction shall be vacated. If the suit is decreed for permanent injunction, still this interim order shall be vacated and you will get a permanent injunction against defendant number 2 so that he may not sell this disputed property to anybody else. So dear students, thank you very much. God bless you all.